Everybody, quiet down, please. My committee members have arrived. We're going to be calling to order in just a minute. I would like everybody to find a seat. If you do not have a seat, there is an overflow room in 502. And before we get started, everybody, there is absolutely no way everybody who is asked to speak today is going to be able to. I want everybody to be assured that if you wish to speak and there is no time, I highly, highly, highly encourage written testimony. I love written testimony. We all love written testimony, and it will be included in the minutes. So please find your seats. We're going to get started in a moment. Thank you, everybody, for your patience. We had a lot of unanticipated participation today. The House Judiciary Committee will come to order. Madam Clerk, will you please take the roll?
Chair Breen.
Present.
Representatives Edwards.
Here.
Carter.
Here.
Pope. Here. Arbit.
Here.
Devendorf.
Here.
Hoskins.
Here.
Cerniglu. Here. Fink.
Here.
Wenzel.
Here.
Wozniak.
Here.
Outman.
Here.
Johnson.
Here.
Madam Chair, you have 13 members present. You do have a quorum.
Thank you. I will take a motion from Representative Edwards to approve and adopt the minutes from our previous meeting. Thank you. Those minutes are now adopted. Today, folks, we are going to be taking testimony and voting out numerous bills. And I want to be very clear today. I'm going to try to hold everybody to no more than 3 minutes. If you have requested to speak and there is not enough time, I sincerely apologize. We are in strange times. And so with some of these bills, these proposed laws that aren't quite ready, but the parties are still negotiating in good faith, and I'm aware that they're negotiating in good faith. I don't want to stop that train, and I want the parties to continue to negotiate. So we're going to be dealing with some issues today that might not seem perfect, but I don't want to kill it so that we can try to hopefully come to a resolution before the conclusion of this term. So with that, we are going to be taking testimony and voting out the following items. House Bills 5882 through 883, House Bill 6011, House Bill 5939, House Bill 5716, House Bill 6085. However, before we get started with those, we have a quick housekeeping matter. Due to a procedural error at our last meeting with the 20-bill human trafficking package, I knew it was too good to be true. We did screw up at one little point. We voted out a substitute for a bill that did not have a substitute. So we will be voting out a human trafficking bill, but we are not addressing human trafficking today. So we are going to start with now House Bill 5838, Carol Glanville, human trafficking. I will take a motion to report House Bill 5838 from Representative Edwards with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. The motion prevails.
That went very well. Thank you. It's a good start. Okay. We are now moving on to House Bills 5741. These are the otherwise known as Stop the Bleed package. We have an H2 substitute for House Bill 5741 before the committee. I will take a motion from Representative Carter to adopt the H2 substitute. Madam Clerk, please call the vote.
Chair Breen.
Aye.
To adopt the H2 sub for House Bill 5741. Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. The substitute is adopted.
I will now take a motion from Representative Hope to report House Bill 5741 as sub H2 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter. Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you. I will now take a motion from Representative Arbit to report House Bill 5742 with recommendation. Madam Clerk, please take the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you. I will now take a motion from Representative Wozniak to report House Bill 5743 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you. We are now going to move on to House Bills 5882 through 5883. Is Representative Hood here? I don't see Representative Hood. Okay. We're going to come back to that then. We're going to do testimony on House Bill 6011. Representative Cerniglu. Oh, wait, never mind. Sorry, Rep Cerniglu.
Room.
Thank you. Representative Hood, could you please introduce your cohort here?
Yes, ma'am. Thank you, Representative Breen, for bringing these bills forward for the consideration of the committee. We appreciate you and your support. We have 3 bills, House Bill 5882, and 5883. And then I wanted to highlight that we do have a 3rd bill underway that will address the Power of Attorney Act and ensure that that act, which has been changed this year, is aligned with the remote witnessing and remote notarization bills that we have put forward here.
For that 3rd bill, I would recommend that you make sure with Representatives Hope and Wozniak, who are resident experts up here, to make sure that that bill is appropriately addressed and attached to
Yes.
this package.
Yes, ma'am. We have been working with both of them in conversation over the last few days, so we appreciate that recommendation. Today, I have here with me Howard Collins, who is an attorney from the Elder Law and Disability Rights section of the State Bar of Michigan, to speak to the details of the bill.
Well, thank you. I appreciate the opportunity to be here and to talk on HB 5882, 5883, and the Power of Attorney Act that's forthcoming. I sit here as a representative and a member of the Council of the Elder Law and Disability Rights section of the State Bar. As this group knows, the section is separate from the State Bar itself, and so the views expressed this morning are those of the section and not of the bar. The State Bar has not taken a position on this issue, as I'm aware so far. The bills that are in front of the committee are a return to law that was in place in sunset. The sunset happened in 2021, July, and so we've been without the tool of remote notarizing in the expanded way that we're asking for here in this bill, and remote witnessing since those times. The need is real, though, and so the people that attorneys like I serve will be well served by having this return to the law in Michigan. Our clients are sometimes homebound, sometimes facing mobility issues. Their ability to get directly in front of their attorney to complete legal documents is challenged. And so having remote witnessing and expanded remote notarization will allow them to complete these important legal documents. I'm grateful that this is a bipartisan set of bills. It is really nonpartisan in application. The practical effects of this are that attorneys will be able to complete legal documents, meet with their clients via technology such as Zoom, which has been quite ubiquitous at this point in most of our existence, and safely, effectively, efficiently conclude the legal business that's in front of them. You know, I had a client who was medically compromised. He wanted his estate plan completed. He wasn't able to come into my office because of his fear for becoming ill if he was in front of my staff in a direct way. And because the law had sunset, we met by Zoom, drafted the documents, reviewed them by Zoom, and then because there was no law in place, we signed his documents while he was in his van. That's not how it should be. That's not appropriate anymore in the 21st century. So putting this law in place is important for efficiency, effectiveness, dignity of our clients. We want to make sure that people have the ability to get the work done that they need to get done. You know, there's been some concern expressed about the safety integrity of this process. We've had an experience under the law already. There are no reported cases that I'm aware of that where someone fraudulently remotely witnessed or remotely notarized. Those cases don't exist. And the reason they don't exist is because I don't think it happens.
Sir, I do need everybody to keep their testimony to about 3 minutes.
I'll wrap up. That said, the Elder Law and Disability Rights section has supported this set of bills and would ask for the passage of this plus the Power of Attorney Act. The reason the Power of Attorney Act, it's separate, so it needs to be opened separately to incorporate both remote witnessing and expanded remote notarization. I will be happy to answer any questions that might be of the committee.
Do we have any questions? Representative Wozniak, I'm sorry.
Thank you, Madam Chair. Anyway, I just want to vouch for Mr. Collins' testimony. I've known him a long time. He's an educator. He actually teaches what we're talking about. So anybody that has any doubts about his credentials, I vouch for him. Thank you.
Thank you.
Thank you for that, Representative Wozniak. Representative Fink.
Yeah, my question would be, do you think that Michigan needs to address in statute the possibility of the creation of completely electronic estate planning documents, and whether this would be an opportunity to if we're going to talk about the electronic notarization of documents on a more, on a lasting basis? It seems to me that there's also the issue of all kinds of records are now being kept almost exclusively electronically. We don't really have an accommodation for that in our law. Do you have any thoughts about that?
So I'll respond two ways. I can tell you that in the past, the Elder Law and Disability Rights section has opposed bills that have come forward. Obviously, if there's a new set of proposals, they'll be considered and responded to appropriately. I recognize personally, now speaking for myself only, we live in an era where that is becoming more and more the norm. So I think that it's coming. It has to be done in a very thoughtful way, though. This is the challenges here are that when you set up a will, you're alive, and when it comes to be acted upon, the person's deceased, and you can't figure out fully what's gone on, right? And so having the process be fully developed and thought through matters.
Yeah, I think that's an answer to my question. What I would suggest is that the elder law and elder and disability section, the probate section, begin to bring forward some proposals on this, because some of us have tried to initiate some conversations and really not gotten a lot of, I will say, helpful feedback, in the sense that we don't really have a plan here. But I appreciate your feedback on it, and I would encourage all of the relevant sections to actually begin to be proactive here. Thank you.
Thank you.
Do we have any other questions from the committee? Okay. Thank you very much for your testimony. We have a bit more testimony to come up right now. I'd like to call up Cynthia Mifsud. And it looks like you are going to be testifying on two bills. And so this is going to be a little dicey. I'm going to ask you still to keep it to 3 minutes and keep it to the bills. Okay. Thank you.
Good morning. Do I push this? Can you hear me? Okay. Good morning. My name is Cynthia Mifsud. I am here today not as just a citizen, but as the daughter who had to watch helplessly as the system meant to protect my mother became the instrument of her suffering. I am the daughter of Betty Hayes, and after 3 long torturous years, over $200,000 in legal fees, and my mother suffering a catastrophic stroke, I was finally appointed her guardian on May 2nd, 2024. The probate bills that are before you today cause me great concern. The bill HB 5883, remote signing for notaries, is very alarming for its potential for elder abuse. Even with existing in-person signing requirements, my family experienced how legal documents can be misused to exploit someone with dementia. On May 1st, 2021, while I was out of state visiting a sick aunt, my mother's granddaughter, who was a notary, had my mother notarize a revocation of my power of attorney and notarize a new power of attorney. She was never held accountable for anything that she did as a notary. We reported her to the notary people, the Secretary of State, and nothing was ever done to her. Remote signing, it makes it easier for the potential for abuse. When someone has dementia, they need more protection, not less. This bill moves in the wrong direction by reducing the safeguards around document signing. To protect vulnerable adults like my mother, this bill needs significant amendments, particularly restrictions on remote signing for individuals with diagnosed cognitive impairment. Without such protections, it risks enabling more stories like mine. In HB 6011, with the trust, I was successor trustee. I stepped in when my mother got dementia and could no longer do her estate. My mother's granddaughter again took the document to my mother's bank that revoked my power of attorney, and she put in another power of attorney. My mother's trust was depleted, paying $60,000 a year for caregivers while I was kept away from my mother, isolated for 14 months and restricted for 2 more years. $50,000 a court-appointed attorney, and $68,000 a guardian ad litem. Tried to build the estate. I'm still in court fighting these fees because obviously my mother was never protected. My mother was harmed. My mother can't even have a conversation with me now. It's absolutely ridiculous. I mean, she was returned to me as can't even hold a conversation anymore. It's horrible. The bill's structured settlement process could give a false sense of legitimacy to such expenditures as the $60,000 for caregivers, all these bills. If they were approved and you only have 45 days to object, well, then you end up with, if they get approved, only the beneficiaries can object, and if you don't object within 45 days, there's no way to go back after them, according to what I read. And I just want to say, when you return home tonight, many of you will call your own mothers. Imagine my situation where I was unable to call my mother. In closing, the cruel irony of my mother's tragedy is it happened within our current legal framework. The problem isn't a lack of laws, it's that our probate courts operate with impunity. When judges can disregard existing protections without consequences, they're not going to honor the new laws. The immunity enjoyed by judges and guardian ad litems has become a shield for misconduct, not a tool for justice. Until we address...
Ma'am, it needs to be to the contents of these bills,
It is the contents of these bills.
not the probate judges.
What do you mean? This is a probate bill. It says probate on it.
Yes, but this has to do with electronic signatures.
I understand
Okay.
that. And that
Please
refers to
wrap up.
probate. I'm wrapping up right now. My mother's story is not unique. It's merely one example of a systemic failure that continues to devastate families across Michigan. And I just ask that you think twice before you pass these bills, because I think they're only going to cause more harm.
Thank you. We are going to pass them out of committee today, I believe, but that's not the last stop. I encourage you to reach out to the bill sponsors and to work with them to see if there's any amendments that they might be willing to consider. Thank you. I now have are there any additional questions right now on these bills? Okay. I'm going to read in some cards. We have Patricia Herndon from the Michigan Bankers supporting the bills 5882 and 5883, as well as another bill we will discuss later. Matt Sowash from the Michigan Land Title Association also opposing the bill, not wishing to speak. And Kath Linwood of the probate section supporting 5882 and 5883, not wishing to speak. I will now take a motion from Representative Devendorf to report House Bill 5882 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel. Wozniak.
Pass.
Outman.
Pass.
Johnson.
Pass.
Madam Chair, you have 8 yeas, 1 nay, 4 pass. House Bill 5882 is reported with recommendation.
Thank you. I will now take a motion from Representative Hoskins to report House Bill 5883 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
No.
Wozniak.
Pass.
Outman.
Pass.
Johnson. Pass. Madam Chair, you have 8 yeas, 1 nay, 4 pass. House Bill 5883 is reported with recommendation.
Thank you. Now we are going to move on to House Bill 6011. Representative Cerniglu. In general, she's here to provide testimony for her bill. Joining via Zoom, I believe, will be Kimberly Snavely from PNC Bank on behalf of Michigan Bankers Association. This bill is to authorizes a process that releases a trustee from a trust without the need to file a formal court account or obtain a release agreement. Representative Cerniglo, tell us about your bill.
Thank you, Chair Breen and members of the Judiciary Committee. As House Bill 6011 seeks to amend Michigan's process of releasing a trustee from a trust. Currently, a trustee is entitled to be released for services to a trust whenever the trustee seeks to resign, is removed, or whenever the trust terminates. The most common methods of obtaining release are to file a formal account with the court having jurisdiction over the trust, or by receiving a release agreement from all interested parties. Both methods can be costly and cumbersome, with the cost of both efforts being paid from the trust itself, and can inadvertently result in a bad breakup when none is necessary. The proposed changes in this bill provide that upon trust termination or trustee resignation or removal, the trustee may send the interested parties a report of the trust for a period of time, such as 2 years, that includes a statement of the net value of the trust assets to be distributed, an estimate of items reasonably anticipated to be received or dispersed, and the amount of any fees, including trustee fees, remaining to be paid. If none of the interested parties makes an objection within the specified objection period, which we set at 45 days, but we will be moving to 90 days at the request of the probate section of the bar, then the trustee is released as if the court had approved on accounting, or as if all of the parties signed a release agreement. Any successor trustee, if the trust is not terminating, bears responsibility for the prior trustee's administration if no party objects during the time period. In addition, if the statutory time period elapses with no objections, the interested parties are time barred from bringing a claim against the trustee. In general, the use of these statutory protocols can be less cumbersome, less costly, and less time-consuming than filing a formal account or obtaining a release agreement. The use of a statutory trust protocol is beneficial to both corporate and individual trustees, as well as the beneficiaries of the trust, regardless of the size of the trust. If signed into law, Michigan would join several other states, including Kentucky, Delaware, Indiana, Maryland, Alabama, Tennessee, and most recently Ohio, who have adopted a statute which authorizes this process. I'm happy to answer any questions, but also we have Kimberly Snavely, Senior Counsel at PNC Bank, on Zoom to testify, and she can probably be better at answering some of the more technical or specific questions.
Okay, Ms. Snavely, are you with us?
Yes.
Hi.
Thank you.
Welcome.
Hi, good morning.
Go ahead if you have anything to add.
The only thing I think Representative Cerniglo did a very good job providing a good overview of the proposed statute. The only thing that I would add is similar legislation has recently also been adopted in most recently Pennsylvania and Virginia as well. So we have 9 states. There's 9 states now that have similar legislation. And then this is also being considered in addition to Michigan, 3 other states.
Do we have any questions for these witnesses? No? Okay. I do have also Jody White, who wishes to thank you, Representative Cerniglo, to testify. Please keep your remarks to 3 minutes and keep it to this bill.
And I'm going to just describe about the bill. The bill that is being changed is from a 2016 Public Act to fiduciary access to the digital assets, access to them, to our money, our family's money. And what I don't understand is that you guys have provided a bill to provide more power and a procedure for the court that has the jurisdiction over these matters when the people have been coming to legislation begging for the opposite. We are actually asking for the judges and the probate people to have more rules and regulations. So I appreciate, because I want to make it quick. My family has been in probate court for 12 years with a trustee. There was 2 of them, co-trustees. And on Thursday, the 21st, Scott Cheater, you guys all know about him, the superhighway of probate. He took on my brother-in-law as a co-trustee, and he was convicted on Thursday, the 21st. We didn't have a really great Thanksgiving because the other co-trustee, the attorney, Thomas Brennan Frazier, I can only tell you his name because it's a public record that he's another co-trustee. We've tried all the things that they have said to get rid of this guy, and he couldn't. He's still there. He's still there. So as much as I appreciate making it easier for attorneys and bankers, we, the people, would just like to keep our assets and keep them intact, and to make sure that laws are being provided to provide more power and procedure for the court that has the jurisdiction over these matters when it comes to the people, because you guys represent us. So again, thank you, Ms. Breen, for allowing me to speak. I had a different speech, but it is pretty horrible when a co-trustee, you can't get rid of them for unsuitableness because they're attorneys and they're part of the bar association. And we would like a meeting with them at any time you guys are willing to help us meet up with this probate gentleman. We are all in. And Mr. Fink, I'd love for you to help us now that you're going to be retired from the, but we appreciate all you've done for this. But you've got time. Thank you.
Thank you, Ms. White, and I would agree that Representative Fink is very astute and helpful, and maybe he can help you.
I don't know if I'll have any more time. We'll see.
Okay. Looking on my massive pile of cards, I don't think I have any additional cards to read in for. Okay. If you have submitted a card or if you've submitted electronic testimony, our amazing clerk, Melissa, will make sure that that is included. I will at this point take a motion from Representative Cerniglu to report House Bill 6011 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards. Yes. Carter.
Yes.
Pope. Yes. Arbit.
Yes.
Stevendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
No.
Wozniak.
Pass.
Outman.
Pass.
Johnson. Yes. Madam Chair, you have 8 yeas, 1 nay, 4 pass. House Bill 6011 is reported with recommendation.
Thank you. We are now going to move on to House Bill 5939, Representative Hadsma, who, from what I understand, has sent somebody else to testify, Jennifer McManus. So thank you for coming to talk to us today. Tell us about the bill.
Thank you. Good morning. My name is Jennifer McManus. I'm an employment and civil rights attorney out of Royal Oak, Michigan, and it's my pleasure to appear before you today. Thank you for allowing me the opportunity to discuss House Bill 5939. This bill is meant to ensure that the citizens of Michigan get the full benefit of all legislation that both previously and in the future may be passed by this legislature and signed into law by our governor. You and I were both selected by the people of Michigan to represent them, you in the legislature and myself in the courts. And we share a duty to the Michigan citizens who choose us to guard and protect their rights. It is because of this shared duty that I'm hopeful that you will recognize the importance of this bill. First, I want to point out that this bill does nothing more than provide internal consistency between the Court of Claims Act, MCL 600.6431, and other Michigan laws so that Michigan citizens can know with certainty when their legal claims must be filed before they become moot. Michigan citizens have the benefit of legal protections thanks to the work of our legislature, and judicial opinion should not abrogate duly passed legislation. The legislation before you, the amendment to the Court of Claims Act, will correct inequities created by the Michigan Supreme Court's issuance of its opinion, Christie v. Wayne State University, in May of 2023. I'm going to use the Elliott-Larsen Civil Rights Act as an example to explain what this means. The Michigan legislature has abrogated its sovereign immunity and allows for the state to be sued under the Elliott-Larsen Civil Rights Act. Both the circuit courts and the Court of Claims share concurrent jurisdiction over claims filed against the state under these statutes. The Court of Claims Act requires that claims or written notice of the intention to file claims be filed in the Court of Claims within 1 year of the claim accruing. Prior to the Supreme Court's Christie decision, this 1 year limitation period did not apply to the Elliott-Larsen Civil Rights Act if the claim was filed in circuit court. Meaning if you filed in the Court of Claims, you had to file the notice within 1 year. If you filed in the circuit court, you did not because you're no longer under the jurisdiction of the Court of Claims. Now, however, because of the Christie decision, all claims against the state, including employment and other claims of harassment, retaliation, and discrimination, must comply with this requirement, even if they're filed in the circuit court. This creates significant confusion for all of your constituents, because the Elliott-Larsen Civil Rights Act provides a 3-year statute of limitations, independent of the Court of Claims Act. Many of your constituents who contact me for assistance have already done what they call their research, right? They've gone online, they've figured out what laws might apply, and they come to me and they say, I have 3 years. And so maybe they sat on their case for a year because they had other situations. They were trying to find another job. They had family matters, whatever was going on. And then they call me after the Christie decision, and I say, oh no, it's 368 days. It's too late for you. This creates two problems. First of all, your constituents cannot possibly know how long they have to file suit. Elliott Larson tells them they have 3 years. Christie tells them they have much less time. Now we're asking our individual citizens to interpret Supreme Court jurisprudence rather than being able to rely on the laws that this legislature has passed. Second, the Christie decision provides two classes of litigants. Litigants pursuing claims against private entities remain the full beneficiary of the rights and time period provided under the Elliott Larson Civil Rights Act, as drafted by this legislature. However, litigants pursuing claims against the state of Michigan now have 1/3 the amount of time to file as their next-door neighbors. All citizens should have the benefit of the full statute of limitations, regardless of who their employer is or regardless of who the wrongdoer is. The law itself does not create two classes of litigants, so Michigan courts should not unilaterally revise duly passed legislation.
Ms. McManus, I'm so sorry, but can you please wrap it up?
Yeah, I appreciate the time you've given me. I just want to emphasize that by passing this revised legislation, these amendments to the Court of Claims Act, the confusion will be eliminated, and the citizens of Michigan will be able to trust that the statute's limitations contained within the relevant laws remain applicable to them. Thank you.
So
Happy to answer any questions.
I'm sure the thousands of people that are watching this online are wondering. I just want to make sure that this is clear. What you're saying is that right now, even if you have a case that is not pending before the Court of Claims, you still have to file a notice with them, even though your case is pending in circuit court.
The applicability to cases that have already been filed is, I won't try to go there right now, but cases that could be filed, yes. So if someone has a case that something happened to them a year and a day ago and they just haven't filed suit yet, and it's against the state of Michigan, of some entity of the state of Michigan, then yes, they have now lost their opportunity to pursue that claim in circuit court.
Do you have any idea approximately how many claims have been dismissed because somebody did not comply with that particular requirement?
I do not. If that's information that the committee would like, I would do my part in trying to help you get that information.
Okay. Representative Fink, you have a question?
Yeah, I mean, I actually have kind of a two-part question. I mean, the first part is when you say cases that may develop or laws that may change. I think you mentioned. Are you talking about the package put together by Representative Brixey relating to statute of limitation modifications, largely arising out of the Larry Nassar situation, or is that not what you're referring to?
Absolutely not, Representative Fink. What I'm referring to are statute of limitations are already in place within the statutes that specifically abrogate the sovereign immunity requiring those cases to be filed within the Court of Claims.
Okay.
So, for example, Elliott Larson Civil Rights Act already has a 3-year statute of limitations, and it allows for those cases to be filed within the circuit court.
Okay. Thank you. And then I guess my second question is, I mean, the fundamental question that I think that this legislation actually brings forward is, does the state actually intend to limit the period of time in which you can make that claim against the state to 1 year? I mean, the Supreme Court, I believe, decided the case you're talking about unanimously, that the statute's unambiguous, that regardless where the case is filed or what the statute of limitations normally is, if you're going to file the claim against the state, you do have to file this notice with the Court of Claims within a year, right? I mean, that's the case law status right now. So then the question for us is really a policy question of, well, do we want to have a longer statute of limitations, or do we want to have the same statute of limitations for claims against the state as other tortfeasors, right?
Right.
And so the question, I think, has to actually be, I think we have to talk about this at a deeper level. And honestly, I don't see how we can just vote this out today without a deeper conversation about this, because the issue of sovereign immunity, I mean, this is like a complex area of law that has a reason. I mean, there's a reason that the state has traditionally been less liable as a tortfeasor than other types of entities, right? I mean, and so I'm sorry, but 10 minutes of testimony and voting on this thing, I just don't think it's responsible, because the potential for expanding the liability of the state, I mean, it might be the appropriate thing to do, and you might convince the legislature to do it, but it's actually a pretty significant piece of legislation. I mean, I know this is only one sentence, but you're talking about potentially changing the amount of liability that the state has in a serious way.
If I may respond briefly, I do not believe that this expands the liability of the state. What I think this does is it clarifies what the Elliott-Larsen Civil Rights Act, which is already passed by this legislature and by which the legislature has already abrogated sovereign immunity. It clarifies that the statute of limitations contained within the Elliott-Larsen Civil Rights Act is applicable to all citizens, regardless of who is the wrongdoer.
But it already is, right? To your point, the sovereign immunity has already been abrogated. The question is, for what period of time can you make that claim against the state? I mean, that's kind of the vestige of the concept of sovereign immunity that it exists under the law as it's currently written, right? I mean, again, I'm with you that the nature of liability or who's liable or whatever, that's already, that is what it is. But I do think that this is a pretty big piece of legislation. I mean, again, I know it's one sentence, it's a short bill, but I think this is a pretty major piece of legislation.
Thank you, Representative Fink. Representative Johnson.
Thank you, Chair Breen. Is there any cases particular recently that came up that kind of triggered this discussion and therefore this bill?
Well, you know, I can tell you that as an attorney myself, when I speak to people, if they approach me with claims and they say, this is just an example, they call me up, they say, this is what happened, this is my story, and I was working for the University of Michigan. I was a University of Michigan employee or a Wayne State University employee or whoever it may be. And they say, and I know, I've looked it up, I have 3-year statute of limitations, right? Because that's what the Elliott-Larsen Civil Rights Act. They look up disability discrimination in Michigan, and that's what they find. And then I say to them, well, when did this happen? Well, it happened 13 months ago. And I say, oh, I'm sorry, there's nothing we can do anymore for you. So that happens regularly, okay? The other thing that happens is after the Christie decision came down, there were people within the employment law bar and potentially within other bars as well who had cases pending before the state of Michigan whose cases were then summarily dismissed because they had not filed that notice with the Court of Claims. And so those cases had been properly filed prior to Christie, and then post-Christie, those cases were dismissed. So there's nothing, I'm not going to suggest there's anything we can do about that right now, but I'm using that as an example of how this Christie decision threw everything in flux for regular citizens. I'm not talking about the most sophisticated people who possibly could have hired counsel the day after the wrongdoing happened to them. These are people that look up the laws that have been passed and say, oh, I have a 3-year statute of limitations. We can't expect those people to understand Supreme Court jurisprudence or to look to the Court of Claims Act and see how the interplay of the Court of Claims Act is with the Elliott-Larsen Civil Rights Act. We have the Elliott-Larsen Civil Rights Act to protect Michigan citizens.
Thank you. Any other questions from the committee? No? I do know that we have some cards and a testimony that was submitted electronically. I do have one from the Attorney General's Department in opposition, and there are others that will be attached to the minutes. But right now, thank you, Ms. McManus.
Thank you for your time.
Thank you. I will take a motion from Representative Edwards to report House Bill 5939 with recommendation. Madam Clerk, will you please call the vote?
Chair Breen.
Aye.
Representatives Edwards.
Yeah.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Dievendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
Pass.
Outman.
No.
Johnson.
No.
Madam Chair, you have 8 yeas, 4 nays, 1 pass. House Bill 5939 is reported with recommendation.
Thank you. We are now going to turn to House Bill 5716, Representative Farhat. And I believe he has one of his local police chiefs accompanying him, as well as, looks like Sheriff Fanis.
Should invite all them up, is that okay?
Make it a party.
Yeah.
Have fun. Go nuts.
You know, I figured the remarkable turnout today was because of this bill, so I might as well bring the best folks I could. Thank you, Chair Breen, and thank you, colleagues, for taking up this very important matter. The House bill laid in front of you folks simply ensures that one's religious protections under our constitutions don't stop when they get booked, that they are able to preserve their abilities and their dignity to maintain their religious beliefs and whether it be a head covering, a scarf, a yarmulke, a turban, and it allows them to maintain that during the procedure of being in custody of law enforcement, while also giving clear guidance to the men and women who are doing the job of keeping folks safe on how to do it without jeopardizing their ability to keep other inmates safe, to keep themselves safe, and keep the person they're detaining safe. Before you is the introduced bill, but I do want to share that we have worked very closely with our partners in law enforcement on some updates on a sub that we're working on, and hopefully we'll have later in the conversation. But for the purposes of today's discussion, I wanted folks to be able to hear from our local chief who's been doing this now, this exact policy for many years with great success, and our partners here from the Sheriff's Association who helped craft this language. So I'll turn over to Chief Shaheen first, if that's okay.
Thank you, Representative.
That mic.
Thank you, Representative Farhat. I'm honored to be here today in support of House Bill 5716, a bill that seeks to uphold the sacred right to religious freedom, even for those that may find themselves arrested in jail. This legislation is a testament to our commitment to human dignity and the principles upon which our nation was founded. Having had the privilege of serving the residents of the great city of Dearborn for nearly 27 years and one of the only Muslim police chiefs in the country, this legislation is deeply personal for me. The First Amendment to the United States Constitution guarantees the right to the free exercise of religion. This right is not suspended once in jail. It is a fundamental liberty that should be protected for all, regardless of their circumstances. Simply put, there's no compelling governmental interest that should prevent someone from keeping their religious head coverings while in jail or having their booking photos taken. State and federal courts across this country have reaffirmed that fact. By allowing individuals in custody to retain their religious head coverings, we're affirming the importance of faith and spirituality in the lives of these individuals. This bill impacts more than just Muslim women. It may also impact Catholic clergy who sometimes wear veils, Jewish people who might cover their heads with a yarmulke, and Sikhs who wear turbans, all for religious reasons. Some may argue that this accommodation poses a security risk. However, it is important to note that the vast majority of religious head coverings are innocuous and pose no threat to jail safety. Moreover, reasonable measures can be taken to ensure that the headwear does not conceal contraband or weapons. I'm proud of my profession and my colleagues at the Michigan Sheriff's Association and the Michigan Association of Chiefs of Police, who are all opposed to it as introduced, but they are in support of H2 Draft 1. I urge you to support House Bill 5716. By doing so, we'll be upholding the highest ideals of our nation and ensuring that religious freedom is a reality for all. Thank you.
Thank you, Madam Chair, members of the committee. It's nice to be in front of you again. By way of reminder, my name is Dan Faunus. I'm the Deputy Director for the Michigan Sheriff's Association. I've got 43 years in law enforcement, first 25 in the city of Westland, where I retired as its chief. My last 15 years in Wayne County for the Sheriff's Office there, where I was the undersheriff for 15 years. I'm going to be very brief in that the two gentlemen that spoke before me were eloquent. I'm mindful of your time, and I don't want to engage in redundancies. What I would like to say on behalf of the Michigan Sheriff's Association is we worked closely with Representative Farhat for months through this process. We opposed the bill as it was initially introduced. We are in support of H2 Draft 1. That is the end result of a careful process that we engaged in. And the two things that I'm most proud of for this, and I want to read them so I don't mischaracterize it. One, it provides uniformity in process and a workable solution for law enforcement. And number two, it provides a means of protecting the constitutional rights of those individuals that have a sincerely held religious belief while they're in the custody of law enforcement. We believe this is a good bill in its final format with the substitute bills that have been advanced. We're hoping that they're adopted on the floor. If that is the case, we're in support of that because we believe this is a solution that is good for members of the public and for law enforcement as well. Thank you very much for your time.
I do have a few questions. First of all, thank you all for being here. It helps to hear from law enforcement. I'd like to know, just to clarify, this is just for people who are being booked. They have not been convicted of anything. Okay. And how often is this happening? I would imagine, especially given the demographic makeup of Dearborn, that's going to be very different from the demographic makeup of Holland or the UP. I'm just wondering if you have any idea how often this is happening across the state or in particular areas.
So I can speak to Dearborn, obviously. In my 27 years, I've seen it happen with some degree of frequency, obviously, considering our demographics in the city. 2 to 3 times a month, you might have an individual with a headscarf that's brought into custody.
Okay. And what happens if, in looking at the bill, there's a lot of delineation, as in they have to have a member of the same sex taking the photograph. There are a lot of protections to ensure these religious safeguards. What happens if you don't have a member of the same sex available in order to help with this process?
So we have addressed that issue, particularly in the sub. One of the things that was an important provision to us to have if it was operationally achievable. So the entity that's making the arrest has to engage in a reasonable effort to come up with a person of the opposite sex. Quite honestly, there's agencies that might be very difficult for them to do. But for example, in Wayne County, 25% of our staff was female staff. That was the same in the city of Detroit. So as you're seeing a larger and larger, and by the way, I'm sort of stereotyping in that the direction of the searches would go one way, but you're seeing more and more the ability for law enforcement to provide the ability to have an opposite sex individual that's associated with it. The nice thing about this bill is it didn't mandate it if you didn't have the ability to do it, and then it would work to the detriment of the operational efficiency of law enforcement if that was the case, but this gives the ability to have an escape mechanism in that if that was the case.
Okay. Representative Fink, you have a question?
I have 3, but genuinely I think that they're short, and I don't really mean any of them to be, I'm not trying to give you a hard time. The first one is you're speaking to an H2 sub, which I think you shared with me this morning, Rep. Farhat, and I want to say thank you for your communication on this topic. We've been talking about it for several weeks, I think, or a couple of weeks anyway, but that's not the version we're voting on today, is my understanding.
That is correct. We did not, unfortunately, get the sub until late last night, so I wanted to have them. Give the committee a chance to review that. So
I guess I just want to kind of note in the background here that the exact text that we were expecting to see here is somewhat in flux, or what it sounds like you're.
There was, I'll say this. Conceptually, it's the same bill. I think in implementation, we clarified things. I think we made sure that we were inclusive. I want to make this very clear to all members of this committee. It's not about one specific group or groups of people. It's about all people who observe deeply held religious beliefs in our state being able to appreciate the protections of the Constitution. And so we made sure that was reflected as well. So it was really just tightening up language so that we clarified that intent, but functionally in terms of the protection and the mechanisms, they're the same mechanism.
Yeah, and I want to say again, thank you for your communication on it, and I recognize that there have been, cases involving members of the Sikh community, or I think there was a Supreme Court case in the 80s about a soldier who wanted to wear a yarmulke. So I'm with you that everything you're saying checks out. I do want to ask about the question about the First Amendment, though, because obviously if the First Amendment requires this kind of treatment, then it doesn't actually matter. I'm not saying we shouldn't, but doesn't actually matter if we adopt this legislation. So I guess I want to clarify, Chief, based on your testimony, which was very eloquent on this point, are you saying that the First Amendment compels the treatment that this law would spell out?
I'm of the opinion, I draw that conclusion, Representative Fink, from the countless lawsuits across the country that have been on this very issue, where communities, departments have paid large sums of money for individuals that have had headscarves and yarmulkes and other religious headwear taken from them while in custody.
Okay, and so again, I guess like the specific question would be either this or something like it would be required in order to avoid a First Amendment violation.
Based
in your
upon
view.
the case law that I've seen.
Okay, if you can share any of that would be really helpful.
There's a number of them across the country, and I just know this from the research I've done over the last 20 years on this very issue.
Yeah.
Rep. Fink, if I may interject as well, there's a case that occurred out of the Michigan Department of Corrections, and we took a guidance from how the ultimate outcome of that case in getting to where we were with the language, specifically regarding sincerely held religious beliefs. We thought that was important. Back to Rep. Farhat's point, the initial bill in concept, we understood what it wanted to do, but language is everything, and it was very important to have the right verbiage in there. And at the end of the day, I think one of the most valuable things that's going to come out of the subs, if they're adopted and passed, is that it will provide a uniform solution for law enforcement to approach these issues and deal with them.
Okay, maybe you and I can talk about the cases in between now and next week. Okay, my last question is, and if you don't have an answer for this, I understand, but we have several issues, at least one court case, and recently a bill that moved out of this committee, which, in my opinion, makes the language about opposite sex or same sex a little bit difficult to interpret. So, I mean, we have a law relating to government records where you could select not only to change your sex from male to female on the records, but to mark it as an X. And then we also have the Roush Rule case where the Supreme Court said that in the context of Elliott Larson, they were interpreting the word sex to include gender identity. So do you think that we have to kind of be a little more specific? I mean, this is, I would say, traditional language about sex distinctions, but we're blurring some of those distinctions in case law and statute now. Do you think that this is going to be clear enough to avoid putting somebody in an awkward position in the future?
You know, what I'll say is this, our intent is to always make sure that the bills we're drafting are enforceable and executable by our partners in law enforcement. I would welcome collaboration with yourself and any members of this committee, as well as our partners in law enforcement, to make sure that the language is uniform and that we're still giving preference to maybe the sex that is comfortable with, the individual is comfortable with, when we can work on that language. But I can't speak to other bills beyond this one. I can only speak to the context of this bill.
Thank you, Representative Fink. That was actually something I thought about, but I did not know how often that might be an instance where the person who is being booked, if they had a particular sex that they preferred, whether that's male, female, something other prefer not to say, whether or not that would cause any confusion when it came to executing what this bill is trying to execute. Are you aware of any instances where this has been a problem?
No, and I may be speaking out of school, but I would think that the onus would be on the individual that's asserting that sincerely held religious belief that they're seeking to protect to put us on notice as to what they're looking for regarding the accommodation. And I think we'd be responsive to that request from them.
Okay. Thank you. I'm going to move on to some other questions, but I want to thank you again for bringing this forward because I grew up in Dearborn before we moved to Northville, and I'm very familiar with the area, and I think this is something that is absolutely necessary in order to protect these closely, dearly held religious beliefs of people. Representative Arbit.
Yeah, happy to wrap this thing up. I just wanted to say that I really appreciate you bringing this forward, Rep. Farhat, and I've appreciated you working with me and making sure that the Jewish community and all of its diversity is included and covered in this bill. And also just really appreciate the interest in this committee in religious liberty and religious freedom. And I think that is a bipartisan interest, an interest that we all should have as Michiganders and Americans. And I hope that we vote this bill out uncontroversially. Having seen the subs, I know that it's really good. And I have full confidence in this legislation. So thank you.
Thank you, Representative.
Thank you, Representative Wozniak.
Thank you, Madam Chair. For the Chief, how often does this occur in your department? Is there going to be a resistance to removing headgear or whatever else it is? And do you do this with other denominations other than one particular denomination?
So I would say on average it's about 2 times a month that we have to accommodate somebody with a religious head covering. We've been doing this, Representative Wozniak, for many, many years at the Dearborn Police Department with no issues whatsoever.
Right. Thank you.
Yep.
Representative, if I may, just really quickly, Chair.
Very, very, very quickly.
I just want to congratulate Representative Wozniak and all the Michigan fans here for beating Ohio State this weekend.
Why are you wearing scarlet and gray on your tie then?
Okay, thank you for that. Before we move on to Representative Johnson's very brief question, I'm going to say quickly go green. And
Chair, I'd like to retract my comments from the record then.
Representative Johnson.
Thank you, Chair. I appreciate the religious liberty focus. As you know, I share that big concern of First Amendment rights. Just because I'm not familiar with the practical working out of how do you determine that there is no contraband or sharp objects or whatever under a head covering? Thank you.
So the Dearborn Police Department will use a handheld metal detector, and we also have an officer of the same sex, conduct a search of the head covering to make sure there's no pins or anything of that nature in there. And I will add, there are times where if we believe someone might be a threat to themselves, we'll substitute the religious head covering with a temporary head covering that were provided by the police department that's very inexpensive as well. So if there is that concern of suicide, what have you, then we'll provide them a temporary head covering that is more of a hood that can go over that couldn't be used to potentially hurt themselves. So all these things you can navigate.
Thank you. Representative Carter.
Thank you, Madam Chair. For those who have never done it, I think in the future or when the opportunity presents itself, if you have a sample so that folks can visually see, to kind of give them an idea of what we're talking about.
Yeah. That's very good. Thank you. Thank you, Representative Carter.
Okay, we are now going to move on to a vote, and I will note that again, we will be voting on the bill that we have before the committee now. There is a substitute available. That substitute might even get tweaked a little bit more before it goes to the floor. And so with that, I will take a motion from Representative Carter to report House Bill 5716 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Pass.
Wozniak.
Pass.
Outman.
Pass.
Johnson.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. The motion prevails.
Thank you. I'm guessing by looking at this crowd, you are all here for our last item of business, unless you are really, really bored. Otherwise, I don't see why you would be here. We have now here House Bill 6085, Representative Rheingans, modifying the cap for damages allowed to be claimed in medical malpractice lawsuits. And again, I would like to stress to everybody, we will try to get everybody in, asking you to limit it to 3 minutes. And I'm also noting that this bill is highly controversial. And because the parties, as I understand it, are also still negotiating in good faith, I want them to be able to continue those negotiations. And with that, just Rep. Rheingans, why don't you proceed with telling us about your bill?
Thank you, Madam Chair and members of the Judiciary. And I do appreciate that we have limited time today, and we have 2 patients here who can speak better to their experience than I'll be able to speak about the technicalities of the bill. So I want to make sure they have enough time. So today I'm here to talk about medical malpractice, and a recent study in the United States has shown that this is one of the leading causes of death, in fact, the 3rd leading cause of death in the United States. And according to Johns Hopkins, on average, over 250,000 deaths per year in the U.S. have stemmed from medical malpractice, which is about 9.5% of deaths. But despite this, only about 700 to 800 cases have been filed on average per year in Michigan between 2009 and 2023. Patients have been unable to seek justice for medical malpractice events because the caps are too low to provide for ongoing financial support for patients with permanent lifelong injuries or for families who have suffered the loss of a loved one. This bill, House Bill 6085, would remove death, and I'm talking about the version that's in front of you, not any subs that have been discussed. We're still negotiating those. So this, as written, would move death resulting from malpractice from the low cap category to the higher cap category. It would clarify existing injuries within the higher cap. The intent there is to focus on the injuries and the functional loss suffered by the patient and not the cause of the injury. It would create exemptions to the caps when a provider's actions were particularly egregious, such as the very rare occurrences of destruction of records or providing care while under the influence of drugs or alcohol. Thankfully rare, adjust our state's current lower cap category and the higher cap category, which those levels are in negotiation. So the bill in front of you is the lower cap is from $549,000 to $1,016,000, and then the higher cap would be changed from 1.5 to 3 million, but those are in negotiation still. I did not sponsor this bill to punish doctors or to reward lawyers. I sponsored this bill to seek justice for patients who are our constituents who have been harmed in the most extreme ways. Of course, providers are just like us, humans who make mistakes. And what we're talking about here are the mistakes that can be life-altering or life-ending for patients. To truly have justice for deaths or severe impairments of loved ones, it really is time to make some adjustments here. Some may suggest that increasing the caps will lead to an increase in frivolous lawsuits, but the data says otherwise. A Harvard study found that 97% of claims involving medical injury and 80% involving physical injuries that resulted in major disability or death did actually have merit, so very high percentages. And very few claims where there was no error found were paid. In fact, the researchers found the reverse, that non-payment where error was involved was actually a far bigger problem. Others may say that increasing our state's caps may cause an environment where medical providers do not want to practice, and we will see them leave the state in droves. That is something that's a big worry of me, but there's other factors that impact that, not just medical malpractice costs, and also this isn't borne out in the data. 22 states and DC do not even have caps on medical malpractice awards and have on average more physicians per 100,000 residents than we do in Michigan. So this means that the existence of caps isn't related to the number of providers, and rather we know it's these other factors like reimbursement rates, insufficient housing, underfunding of schools, or absence of robust transit options that really have impacted and created provider deserts. Some states, including Florida, Illinois, Georgia, Washington, and even more, have found caps to be unconstitutional, and some of them even cite 14th Amendment justifications, which I'm not proposing that we remove caps here today. I'm suggesting that we take this opportunity to better reflect the needs of the patients, our constituents, who develop lifelong injuries or die as a result of gross negligence by raising these caps for the first time in decades. While these incidents happen more often than we would think, they are still relatively rare, and obviously I and many of you, probably all of you, hope that they remain rare. However, when they do occur to our constituents or our loved ones or their loved ones, it is our duty to make sure that they're not deprived their opportunity to seek justice. So thank you, Madam Chair. I urge a yes vote on 6085, and I look forward to hearing from two patients that can better explain this from their perspective than I can.
Thank you. We are very short on time, and we do have several people who want to testify. So I would ask people hold their questions till the end so we can get through this very quickly. I would like to call up Pam Bushley and also Norma DeMott to come and testify. Just come to the table at the same time, please. Thank you very much for being here. You're going to want to press the red button if it's in front of you. I do not care who goes first, but
You're seated. Go ahead.
and I'm sorry because I know you guys have important things to say, and I hate to rush you, but we just want to be able to get through this so we can make sure we get it right. Okay.
Thank you so much for having me and the time to hear my story.
And what is your name?
Norma DeMott.
Thank you, Norma.
So my son is Kenneth. He was born March 18th, 2017. Had he received the proper standard of care, he would have been given antibiotics right after birth. Tragically, there were numerous missed opportunities for timely interventions. Essential medical actions, if taken promptly, could have made a crucial difference between life and death. Time was of the essence, and my son was incredibly vulnerable. Sadly, Kenneth lived only for 2 brief days. A treatable infection was allowed to progress unchecked, leading him to become septic, enter shock, and experience multiple organ failure. Kenneth fought valiantly against this condition until he could no longer. It breaks my heart to think of him enduring such intense suffering and pain. The malpractice cap in Michigan is simply too low. It is vital that we establish accountability for the failures that led to this tragedy and recognize the profound loss of a life cut short far too soon. There must be accountability for the failure to rescue. Kenneth's life mattered, and the current caps do not allow anything close to full accountability. Thank you.
Thank you. I'm very, very sorry about the loss of your son. Okay. Ma'am?
My name is Pam Bushley. At the time of the events in my case, I was a school social worker for children with learning disabilities and autism in the Kentwood Public School System. I underwent an elective hysterectomy in December of 2013. At the conclusion of the operation, the surgeon placed a suprapubic catheter. After the surgery, I was slow to recover. Sorry, this was 10 years ago yesterday. Did not feel I was ready to be discharged, and I was sent home anyway. At home, over the next several days, I remained slow to improve and was not able to produce any measurable amount of urine. The surgeon's staff nurse was informed. I was told not to worry. Over the course of the ensuing weekend, I developed cramps, shivering, and severe low back pain. The surgeon, who happened to be on call, was contacted repeatedly and informed of my symptoms. She never offered to evaluate me. Instead, she assured my husband that I was simply suffering from bladder spasms and prescribed medication to take care of the pain. She said that she would see me on Monday morning. I didn't make it that long. I became confused and remained in extreme pain. The medication the surgeon prescribed was of no help. My husband took me to the emergency room where we learned that I had developed sepsis from a urinary tract infection in the catheter. The sepsis had further progressed to uroseptic shock. I was placed on powerful drugs called vasopressors to keep me alive. Unfortunately, this deprived my limbs of blood flow, so my vital organs could be maintained. After a period of weeks, I underwent staged amputations of my arms and legs, first my hands, then my forearms, followed by my feet, ankles, and legs. I've been living as a quadrilateral amputee now for 10 years. I am grateful for the healthcare providers who saved my life. At the same time, I can assure you that there is no amount of money that can replace a hand, an arm, a foot, or a leg, let alone all three. Thank you for hearing my testimony.
Thank you for sharing that. I know this must have been difficult. I don't see any questions for these witnesses, but I have asked them to hold off. So if you don't mind, if you would like to have a seat, I'd like to now call up Tom George from the Michigan State Medical Society.
Thank you. I'm joined by Mr. Dan Schulte, who is the Medical Society's counsel. And so, yes, I'm Tom George. I'm the CEO of the Michigan State Medical Society. I'm a physician. We represent 12,000 physicians. And I just want to start by saying there was an allusion to negotiations taking place regarding this matter, and you should know that the Medical Society has not been asked to consult or negotiate or give an opinion on any of these issues until today. And as a former member, I'm saddened by the lack of process on an issue that is very, very important. When the legislation was crafted, creating our medical liability system in the 1980s and 90s, it took a decade. And you're attempting to make major reforms in the span of 7 session days. Our association has worked hard with this legislature on many public health issues. I've told my members, we're working with the legislature. We've been involved on many of them for the last 2 years. You've had 2 years to do this, and you wait till the last 2 weeks, and it's just not sufficient time. Now, we've heard a couple things that I want to address. The first is that no amount of money will ever make up for a serious injury or death of a patient. I mean, that is true. No amount will. Yet, the sponsors seem to suggest that Michigan law is insufficient. They point out that we have caps. The caps are on non-economic awards, not on economic damages. Hence, Michigan has had some of the highest awards in the nation. I've included in a handout a Becker's review of a $120 million award earlier this year against Henry Ford Hospital, the second highest in the country. So to say that, the law is restricting plaintiffs and trial attorneys from winning big awards is not true. Just look at the trial attorneys' websites. I went to print up the list of awards they put on their website that they wear as badges. It's their advertising. And many of them are for tens and tens of millions of dollars. So it's not true that the system is broken and we need to fix it so that there's more money going to the plaintiffs. The second assertion that has been alluded to is that this will somehow reduce medical malpractice. And it is true that medical errors are a serious cause of patient death and harm. It is true. And we know from studies that it's not just bad doctors and nurses that make medical errors. It's all of us. It's all doctors and nurses. All of us make errors. And we know from this evolving science that the way to reduce errors isn't through punitive awards. It's through collecting data, coalescing data to find out the root causes of those errors, most of which result from faulty systems. So if the legislature wanted to make a difference and wanted to reduce medical errors, we'd be happy to partner with you. You could have a patient safety commission. You could incentivize error reporting and data collection so that we can look to fix dysfunctional processes that providers often find themselves in. I want to turn your attention to a couple side effects of this legislation. One is it will increase healthcare costs. There is no doubt. And if we compare to neighboring states, we can look at Ohio, Indiana, Wisconsin. They all have caps. Theirs are more stringent than ours on non-economic damages. Our cap is indexed to inflation. It goes up every year. It goes up automatically every year. And we can look at Illinois, which you heard doesn't have caps. So we're in the middle. We are a reasonable state in the middle. And in Ohio, Indiana, and Wisconsin, liability premiums for physicians are half as much. In Illinois, they're twice as much. We know because our association sells liability insurance as a service to our members. So our insurer operates in several states, and they've told us that if you pass this bill, liability premiums are going to go up 37% in Michigan. For our physicians, 37%, and that's going to affect healthcare costs, which are already projected to rise 8% next year. Your constituents do not want you raising healthcare costs. Another unintended effect is the effect it has on physicians and their practices. You heard from Rep. Rheingans that there is some concern over physicians locating, and that this is one of the considerations. It may not be the prime one.
I know.
Well, I don't know that the committee does know, but it is a factor. We are a producer and exporter of doctors. You've increased the number of medical schools. Guess what? They leave. They don't stay in Michigan. So it is part of the factor in determining where physicians practice, and it affects how we practice. Surveys of obstetricians show that when they fear medical liability, they see less high-risk patients. They stop taking high-risk patients. Read this week's Detroit News article.
I need you to wrap it up right now.
This is the problem. This is a serious issue which you're trying to resolve in 3 minutes, and it can't be done. You should vote no. We've also heard that there are negotiations. This is some part of some large deal. Don't let leadership push some deal on you that isn't fully vetted, that your constituents haven't had a chance to opt in.
I really am. There are negotiations continue. I have spoken with your group.
Really?
Yes, I have spoken with your group, and
what this morning?
No, sir. I encourage everybody to keep talking. I do need to move on, and I am so sorry. I really am. We are out of time, sir. Can you just give us your name?
Dan Schulte.
Thank you. And you are counsel for MSMS?
The Medical Society,
Okay.
yes.
I am sorry. I encourage you
Happy to take questions to members outside afterwards.
Okay. Well, Representative Fink has one question, which I'm sure will be very, very brief.
It'll be super quick. As you mentioned, you don't have to be a bad doctor to have made a mistake and been involved in malpractice, so please don't take this as or in a malpractice suit, don't take this as any disparagement. But if you're familiar with how these things usually work, is it true that most of the time in a medical malpractice case, the attorneys receive a third of the award that the patients get after costs that the attorney incurred happen? Meaning, if we increase the overall amount of the award, the attorneys will actually make a greater percentage of the overall award than they do today?
That is absolutely true, and make no mistake about it. Passage of this bill will make medical malpractice cases a better investment for plaintiffs' lawyers. And I'm not just picking on the plaintiffs' lawyers, because for every case that's filed, it's got to be defended by someone, and the defense bar is just as anxious as the plaintiffs' bar to see this passed for that reason. More cases and more work and larger awards. What's not to like if you're a lawyer?
Indiana and Wisconsin both have caps on attorneys' fees, which we do not have.
Thank you, sir. I'm now going to call up Brian McKeon and Steve Goethel to give the briefest testimony ever, please.
Good morning. Thank you for the opportunity to speak with you. My name is Steve Goethel. I'm going to jettison everything that I had written because I realize time is of the essence. I'm a malpractice lawyer. I've spent the last 42 of 45 years practicing with concentration on medical malpractice cases. When you listen to the stories of people like Pam Bushley, who I represented here, you would seriously wonder why there are any damage caps whatsoever. Yet in Pam Bushley's case, the value of each one of her extremities was limited to $113,750. That's what she was allowed to recover for the non-economic loss of her extremities. I don't think any person in this room would be willing to sign on to that kind of deal. I read the editorial earlier this week that this bill pitted the trial lawyers against the doctors. Respectfully, I disagree with you completely. What this bill is about are people like Pam Bushley and the other clients that I have here with me today in the medical malpractice insurance business. The medical malpractice insurance business over the last 14 years, give or take, the same time frame that I'm going to give you data on the number of malpractice filings in this case, has taken in 3 times the amount of money that they have paid out in their losses. Taken in $3 billion, paid out $1 billion, a little over in each instance. It's a very profitable business. At the same time, in Michigan, over this same time frame, we have averaged between 600 to 800 cases per year. That's it. This legislation would not make it any easier to bring a case in Michigan. It's darn hard to do it. Brian and I know this. We've been doing this our entire careers. It's hard to bring a case in Michigan. That's why there are so few cases that are filed. This is not going to make it any easier to file cases whatsoever. Zero. What this does, it corrects some of the massive injustices in the existing system that make the current laws regressive, so that people who are injured worse, like Pam, or people who have lost a loved one, are punished the most severely. This would flip that around, so at least these people, the Pam Bushleys of this world, would be allowed to recover under the higher damage cap. It also creates exceptions for gross negligence, fraudulent concealment of medical information and medical records, and physicians that are acting under the influence of drugs or illicit alcohol or illicit drugs.
Thank you, sir. We're going to get kicked out of this room in 4 minutes. So I'm going to ask that we move on to Mr. McKeon. And again, I'm sorry, everybody, because we do need more time on this issue, and there will be continued discussions.
I've also been representing victims of medical malpractice for over 40 years. Michigan's caps are completely unreasonable, unfair, and they're profoundly unjust. They're too low, and the exceptions for a higher cap are far too narrow. I've represented other women just like Pam who've lost all 4 extremities because of failure to treat infections that led to sepsis. Other examples of patients I've represented, people who are blind from birth, permanently blind, people who are deaf, people who've lost a spouse, a child, severe permanent aphasia, they can't speak, loss of hearing, loss of voice, vestibular dysfunction, so they can't walk, can't function in society, permanent kidney damage requiring permanent dialysis, severe disfigurement, a child, a newborn having a brachial plexus injury and a clunky palsy where they can't use their upper extremity, a lifelong injury, and these damages are not even subject to a higher cap. They're $500,000 injuries, and the economics of the practice of law need to be considered by you. I met a client who lost their child, and they came to me with a letter from a lawyer rejecting their case, saying the damages in the case weren't sufficient for him to take on her case.
Sir, I'm so sorry, but we have a question from Representative Outman.
Sure.
Thank you, Madam Chair, and thank you, gentlemen, both for being here. I just want to address one of the things that you raised earlier, and it doesn't seem like this legislation is going to make it any easier to file, just maybe more lucrative in nature, but help me as a non-attorney. Walk me through non-economic damages. Are these
pain and suffering,
intangible things?
Loss of enjoyment of life, not replacement services or wages, okay? And those are capped. And the reality of the situation is a lot of lawyers won't take cases involving death of the elderly. They won't take cases involving death of children who don't have financial dependence. It disenfranchises people and prevents access to justice. By raising the caps and extending the higher cap to broader categories, then we're going to expand access to justice and let more people be able to hire an attorney.
So when
We
they
have to pay
when they
costs.
say non-economic damage, think of things like pain and suffering and immeasurable things.
All right, folks, we're going to get kicked out. So I know discussions are continued. I'm going to now quickly call a motion to report House Bill 6085 from Representative Edwards. Madam Clerk, please call the vote.
Chair Breen. Aye. Representatives Edwards. Yes. Carter.
Yes.
Pope.
Yes.
Arbit.
Pass.
Stevendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No, she's gone.
Okay. Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 7 yeas, 4 nays, 1 pass. The motion carries.
Seeing no further business before the committee, the House Judiciary Committee stands adjourned.